My next question is to Shreya.
Yeah.
We have heard a lot about the corporate residency, and Nishit also mentioned that we had a very good test for determining the corporate residency for the companies.
Yeah.
Has anything changed on that front?
Yeah, in fact, I would say this is a very major change. So, historically and prior to the change in law, India used to have two tests for residence in India. The first was if a company was incorporated in India, it would be a resident in India. And the second is if it was wholly controlled and managed from India, it would be a resident in India. Now, when case law has looked at this concept of control and management, and one very famous case looked at a situation where there was a Singapore-based company which was wholly owned by Indian residents. It had one director in India who was the real decision maker, and it had one nominee director in Singapore. And even in that case, the court held that the company was not wholly controlled and managed from India because of the fact that there was this nominee director outside India and board meetings used to take place outside. Now, what has changed is that they have changed the whole control and management test to a place of effective management test. And while they have picked this up from the OECD international standards on residency, the one variation is that they have said that a place of effective management, even if it exists in India at any point during a given year, creates a residency exposure.
Even one day.
Even one day, right? So if you compare this with the international norm, which requires substantial residence over the course of a year, you potentially have a situation where a company can be resident in 3 countries at the same time, right? One is the country of incorporation, one is the OECD country where it is substantially resident, and one is India if it has a place of effective management even for a day. So that's a bit of an anomaly. Now, I think it's also important to talk about who this test and who this change can impact, right? Today, it's become more and more common for Indians to look at countries outside for the purposes of global expansion, right? So, Indian businesses set up businesses outside, have holding companies offshore. Indian fund managers have carry vehicles offshore in the form of personal holding companies. When you look at all of these kinds of structures where you do have owners and decision makers sitting in India, what this test now does is that it makes it possible for India to tax the global incomes of those offshore companies, right? So a standard example would be like a Flipkart kind of example, right? Where the owners are resident in India, there is a company offshore. Now, what's going to become crucial here is that if you want to look at whether that company offshore is a resident in India or not, there are certain factors which are looked at under the OECD test. So the first is where do the board meetings typically take place and where are the decisions in substance made. The second is where does the CEO decide and where is the decision making of the CEO taking place. The third is where is the day-to-day management of the company taking place, which in these cases is likely to be offshore. The fourth is where are the books of account of the company kept. And the fifth is which laws apply to this offshore company. So I think all of these should still be possible to satisfy in a way in which that residence doesn't shift to India. But now it will be more difficult and it will be more challenging to ensure that this test is in place at all points in time. Because any time during the year can bring that company to be a resident.
These tests are under OECD guidelines, right? But I think what the fine print says is it only says that if the management and decisions are taken in India, it will be considered as place of effective management.
That is
so we are not sure whether tax authorities will apply the same test as under OECD or they will go by the generic definition of where the management and decision making is happening.
So our current definition of place of effective management has been taken from the OECD.
Okay.
So I would be very surprised if they don't respect OECD standards while applying this definition. But of course, we need to see how it pans out.
So one of the interesting things which will happen is between 2005 to 2014, a lot of carry structures were set up outside India by Indian GPs.
Correct.
In the form of personal holding companies, in the form of trust.
Yeah.
And the comfort which they were getting is that because there is a personal holding company, there is a blocker entity. So if the fund is distributing carry to that entity, it does not result in an income directly in the hands of the Indian GP. and they can use that money to invest abroad, or any of the kids are working abroad, they can use it for their purposes. But with this concept of place of effective management, if that personal holding company itself is considered as a resident of India, because the management and decisions are being taken in India, the carry distribution by the fund to the company will be considered as income of an Indian resident and be taxed in India. And not only that, when that company distributes income to the Indian GP, because that foreign personal holding company will be considered as Indian tax resident, there is also a risk of an additional dividend distribution tax when it pays this income to the Indian GP. So lot of these carry structures will have to be relooked at as far as the Indian GPs are concerned, to ensure that there are no loopholes in the repatriation of carry to the personal holding company and then to the GP. The other thing which we have been seeing in the last couple of years is there have been a lot of externalizations which have happened, especially of the e-commerce and medtech type of companies. And Flipkart, as you said, is an example which is there. But a good part with e-commerce companies is all of them are loss making. So even though they are tax resident of India, it may not impact them much. But at some point in time, they will become profitable, or for other IT companies which have externalized for ease of listing outside India, for taking care of the exchange control risk. I think for them this is going to be a difficult change to satisfy, because as you rightly mentioned, CEOs and the entire business is being run from India. So whether they will be able to meet with some of these tests which OECD has prescribed. So it's going to be quite interesting for this. And not only that, even all the big groups like Tata's, Birla's, who have offshore structures.
Today there are various reasons why you would set up an offshore structure, right? And I think this is the tax provision is a little out of sync with that, because it is in some ways like a backdoor control foreign corporation kind of provision, where they're saying that we don't want you to defer the income from these offshore assets, which is why we're going to shift the residency of the company to India. But the fact is that today we have exchange control and other regulations in place. All companies are living with an exchange rate risk. And sometimes it just makes business sense to have your holding company outside rather than have it from India. And I think those are the kinds of structures that will really be impacted today.
I just wanted to make one comment on this, and because this is very relevant, because Singapore is becoming very important for these structures, and a lot of Indian corporates are finding a lot of comfort with Singapore as a platform for going global, whether Asia Pacific or even global, for global listings, for consolidating value, expanding into global markets. So then the issue is, if India has its own concept of residence, conflicts with, let's say, what Singapore has, we don't want to end up in a situation where there's double taxation, so which the treaties may not be able to resolve. So those are the challenges, and definitely we need to be closely addressing that. And again, I think in terms of timing, we could probably quickly move to the other major topics. So one, of course, is the changes in the taxation of ADRs and GDRs. Nishal, what's the impact?
I'll quickly take this up. So as we know, there was a 1993 scheme for FCCBs and ADR GDRs, where only equity shares of listed companies were allowed as underlying securities for depository receipt. With the SAU committee report, the 93 scheme was replaced by a 2014 scheme for depository receipt, where all types of companies, whether it's private or public, whether underlying as equity shares, preference shares, listed bonds, all types of securities, whether investors could be Indian resident, foreign resident. So pretty much the entire depository receipt regime was opened up for all types of companies and all types of investors. The expectation was that, in line with the SAU committee report, the finance minister will give exemption for transfer of DRs to a non-resident for all types of securities. Unfortunately, what has happened is that the finance minister has stuck with the same exemption which was there earlier, which means equity shares of a listed company will be allowed as an underlying for the purpose of tax exemption. All other types of securities will still be considered as taxable under the Indian Income Tax Act. Now, one interesting thing which has happened is, between the provision which was introduced for ADR, GDR earlier, and the proposal of budget 2015, Companies Act 2013 was introduced, which mentioned that which changed the definition of listed company. Earlier, the definition under Companies Act was of a public listed company. It was changed to a listed company. And listed company definition is if any of the securities of the company are listed on a recognized stock exchange. So one interesting structuring avenue which could be available is for an unlisted company, if its debentures are listed but equity shares are unlisted, there could still be a structure which could be worked out in the form of depository receipt, where the investor can hold the DR with an underlying unlisted equity share, but because of the listed debentures, the company itself will be considered as a listed company. There is a possibility that there could be an exemption which could be available to the investor in case of transfer of this depository receipt to another non-resident. So I think that's a limited structuring possibility which is there on the depository.
Yeah, thanks, Mr. Shreya, very quickly, the proposals to tackle this issue of black money, money laundering. How is the government approaching this?
Okay, so I'm only going to make 3 quick points because I know we're out of time. The first is that concealment and evasion, including filing incorrect returns, is now an offence which can result in severe imprisonment. This is aside from the penalties which can be levied for such offences. So the emphasis on information exchange and transparency is even higher, much higher than ever before, and it's only likely to continue. So anyone who has offshore structures, including carry structures, offshore companies to buy property, all of them should be aware of this change in law. The second is that beneficial owners must now file returns even if there's no income from their assets. And the third is that money laundering has now been made a predicate offence, which means that today if you have tax concealment, then from under the PMLA, the Prevention of Money Laundering Act, that is now a predicate offence, which means that the consequences are much more severe. So briefly, that's about it. There are of course a lot of finer points, but in the interest of time, I think people should just be aware that if there are offshore assets, they should be very, very careful about how they handle this.
And so this is again going to impact a lot of the structures for Indian residents, entrepreneurs, for fund managers in India.
Correct.
Because disclosure is a very key issue and something which has to be taken seriously. Of course, moving on to the last, and then we'll of course have some concluding comments and open up to Q&A. Nishchal, what are the key regulatory changes you think are going to help investors?
Sure, I'll quickly touch upon 3 or 4 important regulatory changes. I think the first one is the SARFAESI protection, which is currently available to banks for enforcement of security and recovery of dues, has been extended to non-banking financial companies which have an asset under management of 500 crore or above. So this is a very significant step for the financial services sector. Especially in light of the Usha Thorat committee report, where they had recommended that NBFCs should be given the same status as far as SARFAESI protection is concerned as banks. And if you look at it, pretty much both are involved in lending activity. So there was no reason why SARFAESI protection shouldn't have been given to NBFCs earlier, but it is better late than never. It is here now, and it will be given to NBFCs with more than 500 crore of assets. Second important change is there is some overhaul of exchange control regulations which is going to happen. The finance minister only touched upon it, but we'll get more detailed fine print later. But what is going to happen is right now the equity and the debt investments are equity and debt instruments are handled by Reserve Bank of India in consultation with central government. What central government has proposed is that going forward, all equity instruments will be under the control of central government, and Reserve Bank of India will be responsible only for debt instruments. Now, this is a very significant step in as far as exchange controls in India are concerned, and it looks like the reason why these changes have been made is in line with the capital controls. Because as far as equity instruments are concerned, it's more of a policy issue as compared to Reserve Bank of India's role, which is more of a regulator. And that's where the government is looking at taking over the powers on some of these equity instruments from Reserve Bank of India. The other issue which is typically faced is that the Department of Industrial Policy and Promotion, or DIPP, they issue press notes which are in turn incorporated by Reserve Bank of India into the exchange control regulation. So somewhere for equity foreign instruments, there are two authorities which are looking at it, central government and Reserve Bank of India, and we have always seen that there is some disconnect between the two, like on the put option issue, which became a big issue from 2009 to 2013. Reserve Bank of India had taken a very hard stand on that issue, that put option should not be allowed. As compared to that, central government through DIPP was quite comfortable with the concept of put option on Indian residents. So because of some of these issues where the RBI took very hard stand, it looks like central government has decided to take away some of the powers from Reserve Bank of India. At the same time, there were certain procedural issues on press notes which also they will sort out through this amendment. So I think that's another change, but I think devil lies in details, so we'll have to see the fine print as to whether it applies only to inward investments, or even out to overseas investments or immobile property regulations. Will there be any changes which will be made to that? Another important change they have made is they have consolidated the FDI and FPI caps. Now again, we need to see the fine print, but this is a very important step for some of the sectors like power exchange or commodity exchange, where there are FDI and FPI limits. But the problem which a lot of these exchanges face is that because these are all unlisted exchanges, the FPI limit as such has no meaning, because FPIs are allowed to buy stock only on the floor of the exchange. So for unlisted stock, they still have to approach the regulator. So one of the things which has happened is in a couple of cases where 26% FDI was permitted and 23% FII, the 26% FDI limit has got exhausted. There are more investors who want to acquire the stake, but because FPIs cannot acquire shares on the other than on the floor of the exchange, the 23% limit is remaining unutilized. With the clubbing of the FDI plus FPI or FI limits, an FDI investor can go up to 49% or an FPI investor can go up to 49%, as long as the total foreign investment does not go beyond 49%. So this is a very welcome step for some of the sectors which have FDI and FPI limits. And the last major change has been on the government is proposing introduction of a bankruptcy code, which is again going to be a game changer for the industry, especially because the bankruptcy, India does not have a formal bankruptcy law. We had SICA and BIFR, which were not successful in achieving the objective for which they were created. And as compared to that, if you look at developed countries like US, there are concepts of Chapter 11 bankruptcy, Chapter 7 bankruptcy, where it is easy to revive the company without any issues from the creditors, and creditors and lenders also work together for the revival. So overall, a very positive step for the foreign investors, and this